Welcome to Inside the Deal. I'm Suzanne Stevens. With me today is Stephen Gulotta. Stephen heads the New York corporate group for the law firm Mintz Levin. Stephen, you wrote an article for the Deal News Weekly recently on how corporate boards can prepare and how they should act in the event of an unsolicited bid. We know that it is the board's fiduciary duty to act in the best interest of shareholders, but how exactly is that measured?
Well, Suzanne, typically the rule that governs is something that's referred to commonly as the business judgment rule. And what that indicates is that the court is not likely to substitute its judgment for the judgment of a board that is acting on an informed basis, in good faith, and is disinterested as to the subject matter.
And are there particular variables that a board needs to think about how they're acting? Should they have to prove that they acted in good faith?
Well, in any instance where proof may be important down the line, you have to create a record that reflects that you acted in a deliberate manner, that you considered all of the salient facts, and that you, in a takeover context, typically that you engaged counsel and other professionals to assist in the matter, and if there are any conflicts of interest that may arise, that you've dealt with them accordingly.
What are some of the salient facts that a board needs to consider when approached with a hostile bid?
Well, obviously one is price,
yeah,
and other terms of the offer as well. Whether or not the bidder has the ability to consummate the transaction, what market conditions are, and what the company's prospects are long-term if it were to stand alone.
We have seen some deals go hostile lately. We've seen CF Industries go hostile in its bid for Terra Industries. We've seen Roche go hostile in its bid for Genentech. And in both those cases, the chief executive of the target also serves on the board. So what do boards need to do to prevent the conflict of interest that arises when there is a hostile bid on the table?
Well, if you have an officer who is also a director, that's not in and of itself a conflict of interest. It oftentimes is if in fact the officer is going to stay on and would be serving a different master after the deal, or in a leverage buyout or management buyout situation where they're actually involved with the deal. Usually a little less likely in a hostile situation. Where one does exist, then steps should be taken to insulate those conflicts. And one of the most typical you see is for a special committee of disinterested directors being appointed, and that committee is given broad powers to evaluate the transaction, negotiate the transaction, and recommend it to the entire board.
When directors do reject a hostile offer, they have to defend that decision. How do they do that?
What the board would need to do to protect itself and to support that would, again, depend on the circumstances. And if there are no conflicts and the board is acting on an informed basis in good faith, we're back to the business judgment rule.
It all comes back to the decision-making that goes into vetting the offer initially.
Correct.
Stephen Gulotta with Mintz Levin, thanks so much for stopping by.
Thank you very much, Suzanne.
I'm Suzanne Stevens. Thanks for watching Inside the Deal.